We ready? Start. By no means it is suggested that whenever such a charge of rape is made where the victim is a child, it has to be treated as a gospel truth and the accused person has to be convicted. Stop. We have already discussed about the manner in which testimony of the prosecutrix is to be examined and analyzed in order to find out the truth therein and to ensure that deposition of the victim is trustworthy. Stop. At the same time, after taking all due precautions which are necessary when it is found that the prosecution version is worth believing, the case is to be dealt with all sensitivity that is needed in such cases. Stop. In such a situation, one has to take stock of the realities of life as well. Stop. Various studies show that in more than 80% cases of such abuses, perpetrators have acquaintance with the victims who are not strangers. Stop. The danger is more within than outside. Stop. Most of the time, acquaintance rapes when the culprit is a family member are not even reported for various reasons not difficult to fathom. Stop. The strongest among those is the fear of attracting social stigma. Stop. Another deterring factor which many times prevent such victims or their families to lodge a complaint is that they find whole process of criminal justice system extremely intimidating, coupled with absence of victim protection mechanism. Stop. Therefore, time is ripe to bring about significant reforms in the criminal justice system as well. Stop. Equally, there is also a dire need to have a survivor-centric approach towards victims of sexual violence, particularly the children, keeping in view the traumatic long-lasting effects on such victims. Stop. Stanza. After thorough analysis of all relevant and attendant factors, we are of the opinion that none of the grounds on which the High Court has cleared the respondent has any merit. Stop. By now, it is well settled that the testimony of a victim in cases of sexual offences is vital, and unless there are compelling reasons which necessitate looking for corroboration of a statement, the courts should find no difficulty to act on the testimony of the victim of a sexual assault alone to convict the accused. Stop. No doubt her testimony has to inspire confidence. Stop. Seeking corroboration to a statement before relying upon the same as a rule in such cases would literally amount to adding insult to injury. Stop. The deposition of the prosecutrix has thus to be taken as a whole. Stop. Needless to reiterate that the victim of rape is not an accomplice and her evidence can be acted upon without corroboration. Stop. She stands at a higher pedestal than an injured witness does. Stop. If the court finds it difficult to accept her version, it may seek corroboration from some evidence which lends assurance to her version. Stop. To insist on corroboration, except in the rarest of rare cases, is to equate one of who is a victim of the lust of another with an accomplice to a crime and thereby insult womanhood. Stop. It would be adding insult to injury to tell a woman that her claim of rape will not be believed unless it is corroborated in material particulars, as in the case of an accomplice to a crime. Stop. Why should the evidence of the girl or the woman who complains of rape or sexual molestation be viewed with the aid of spectacles fitted with lenses tinged with doubt, disbelief or suspicion? Question mark. The plea about lack of corroboration has no substance. Stop. From the evaluation of the prosecution material, Discussed above, it is abundantly clear that the evidence brought on record contains positive proof, credible sequence of events, and factual truth linking the respondent with the rape of the prosecutrix and had criminally intimidated her. Stop. Hence, respondent is found to be guilty for offence under sections 376 within bracket 2 within bracket F and 506 of IPC, since he committed rape with a minor girl aged 9 years. Stop. It is pertinent to point out at this stage that at the time of deposition of the prosecutrix in the court, the trial court had no opportunity to see her demeanor. Stop. Stanza. It appears that after hearing the arguments of learned counsel for the parties, the learned tribunal came to the conclusion that the accident took place due to rash and negligent driving of DCM truck bearing registration number UP 78 and 3907, and in the said accident the deceased Dr. Rajiv Kumar had received serious injuries and due to that he died. Stop. The tribunal further came to the conclusion that at the time of accident the offending vehicle was insured with the United India Insurance Company Limited and the policy was valid on the date of accident. Stop. The tribunal also found that at the relevant time all the papers relating to offending vehicle, that is driving license of the driver, registration certificate, permit and fitness certificate, etc. are valid and effective. Stop. Thus the insurance company is liable to indemnify the owner. Stop. The learned tribunal, after discussing the materials available on the record, further came to the conclusion that the claimants are entitled to receive compensation to the tune of rupees 16,39,320 with 6% interest. Stop. Against the aforesaid finding by which learned tribunal assessed the compensation, this appeal filed by the claimants and appellant further prayed for enhancement of the compensation. Stop. It is submitted by Shri Vidya Kant Shukla, the learned counsel for the appellant, that the learned tribunal, while assessing the compensation, had deducted 1/3 amount towards the personal expenses of the deceased. Stop. It is submitted that in the instant case, on the date of filing of claim application as well as on the date of passing of judgment, altogether 5 persons were dependent upon the deceased. Stop. Thus, as per the judgment of the Honorable Supreme Court in Saria Verma and others versus Delhi Transport Corporation and another reported in within bracket 2009 6 SCC 121, only 1/4 amount is liable to be deducted from the total income of the deceased towards personal expenses. Stop. It is then submitted that the learned tribunal, while assessing the compensation, had arbitrarily refused to add any amount in the income of the deceased towards future prospect. Stop. It is submitted that admittedly at the time of accident the deceased was working as animal medical officer under the state government. Stop. The tribunal assessed the age of the deceased as 48 years. Stop. Thus, in view of the judgment of the Honorable Supreme Court in Saria Verma within bracket Supra, it is imperative for the tribunal to make addition of 30% in the income of the deceased, because the deceased was in the age group of 40 to 50 years. Stop. It is further submitted that the learned tribunal had wrongly deducted rupees 16,420 from the income of the deceased, which the claimant number 1 is getting from the state government towards family pension. Stop. It is submitted that in view of the various judgment of Honorable Supreme Court and of the court, family pension received by the widow of the deceased is not liable to be deducted from the income of the deceased. Stop. Therefore, it is submitted that the entire assessment of compensation made by the tribunal is illegal and against the law laid down by the Honorable Supreme Court. Stop. Stanza. On the other hand, Shri G.K. Srivastava, learned counsel appearing for stop over.